Welcome to Canada's most irreverent talk show. This is the Andrew Lawton Show, brought to you by True North.
Hello and welcome to a special edition of the Andrew Lawton Show, Canada's most irreverent talk show. It's not a brand new edition. Normally on the weekends, we'll rerun some of the notable interviews we conducted throughout the week. This is a bit of a different week, though, so I wanted to do something a little bit special here because we had the breaking news on Tuesday of the federal court's decision finding the federal government's use of the Emergencies Act to be unconstitutional. We had some early reaction from Christine Van Geyn, who's the litigation director for the Canadian Constitution Foundation, and then we had her back on the next day on Wednesday's show to delve into it in a bit more detail. And I thought that either one of those in isolation wouldn't be a complete picture of what was a very fascinating pair of discussions about the ins and outs of this case, about what it means and for the law, for the country, politically. So I wanted to bring you both. This is my interview with Christine Van Geyn the very first day, the day that this decision came down from the federal court, really less than an hour after it did. So this was just the product of both her and I trying to capture as much as we could before the live show began that afternoon at 1 p.m. Eastern. Christine, I know you've not had, lawyers are very speedy readers, but I know you haven't had time to fully digest 190 pages just yet. But what's your early reaction on this case here, and what was your role in it?
So our role, we were one of the parties that brought this. This was brought by the Canadian Constitution Foundation, which is a national legal charity that fights for fundamental freedoms in Canada, as well as by the Canadian Civil Liberties Association, as well as by another organization called Frontline Nurses, and by some individuals who had been affected by the emergency measures. For example, individuals who were arrested for breaching, or I guess they actually weren't charged under the emergency measures, but they did have their bank accounts frozen. So the reaction is I'm absolutely thrilled. I didn't know what I was expecting. You know, you kind of try to brace yourself when you are dealing with this complex litigation that goes on for extended periods of time. I mean, I didn't know what to expect. My best hope, I think, was surpassed with this, because we really won on everything. The crux of this case is that the invocation of the Emergencies Act in response to the 2022 Freedom Convoy was unreasonable and ultra vires, which means outside the scope of the authority of the government. And then the other major issue was whether or not the actual regulations that were created under the Emergencies Act, which is prohibitions on gatherings that prohibited people from protesting, and or going to a prohibited protest, and then the economic measures, which ended up freezing people's bank accounts. And the court found that those measures were unconstitutional. They violated the Canadian Charter of Rights and Freedoms. And there's also some discussion in the case about the Bill of Rights. I mean, I'm 90 pages into the decision, which I got less than an hour ago. I'm trying to get through it as quickly as I can for initial reaction, just to see what the big issues are. And then I'm going to obviously do an even deeper dive after this. But my initial reaction is this surpassed my expectations. This is a wonderful day for fundamental freedoms in Canada, for the right to protest, and a wonderful day on, I mean, I think a lot of Canadians throughout the pandemic had their faith in our justice system really challenged, because there were a lot of decisions that didn't come down the way we had hoped. This is a huge exception. And I think that in the context of the pandemic, the invocation of the Emergencies Act was the most extreme piece of government overreach. And here we have a court slapping down the Trudeau government for having done that.
And just to put a finer point on this, and please, if I've misrepresented this, correct me, but as I understand it from what you said and what I've read so far, the court has found that there was no emergency, basically, in keeping with what the Emergencies Act has said. And even if there were, the measures employed were not constitutional. Am I understanding that correctly?
So I haven't got to the second part of your question yet, but I'll read directly from paragraph 255 for you. For these reasons, I conclude that there was no national emergency justifying the invocation of the Emergencies Act, and the decision to do so was therefore unreasonable and ultra vires. Should I be found to have erred, he then goes on to discuss some of the different threshold requirements, because the invocation of the Emergencies Act, that piece of extraordinary legislation, actually has a number of internal thresholds, like threat to the security of Canada and a requirement that the law be a law of last resort. Now, 90 pages in, I'm not at those parts yet, and I don't, and I haven't got to the charter arguments on the actual regulation, so I can't comment on that yet. But I know the result, which is that they were found to have been a charter breach
and not saved by
and not
section 1 of
saved
the
by
charter.
Section 1.
Let me just pull ourselves out of this decision for a moment here, and I just want to, I mean, maybe this is a bit of a civics lesson for people, but we went through this massive public order emergency commission last year, and at the end of that, Justice Rouleau, or Commissioner Rouleau, had concluded that the Emergencies Act was satisfied. That threshold was satisfied. So which is more important, really, and how do we rationalize and sort of reconcile these two seemingly, well, not seemingly, these two inherently contradictory findings?
This is a really important question. This case is no question more important. The actual decision from a court has much more weight. The Rouleau decision has no precedential value. It would be of political consequence, but I don't want to, invalidate that as an exercise, because one of the really important things that helped us to actually achieve this result in the court case was because the Rouleau Commission had this extreme level of transparency, and we were able to access all kinds of cabinet documents that we otherwise would not be able to access,
Mm-hmm.
which actually we had, in this case, the government had been fighting us over the disclosure of these documents that we wanted, and we were able to access them because they ended up becoming public through the Rouleau inquiry. So that, even though I totally disagree with the result in that inquiry, it still was a really important part of the process that led us to this result, which has a huge bearing and weight on how this emergency legislation can be used in the future. I think the long-term impact of this decision is that this will rein in some of the concerns that we had over the government now having, unleashed the Kraken, and they've now used this piece of extraordinary legislation. I think there's going to be a lot more restraint now because they've really been slapped down for this. This is an absolute loss for the Trudeau government. They
I know this
couldn't
is
they
not.
couldn't have lost worse. Like, this
Yeah,
was the
that's fair. And
worst
I
case
know this is
scenario.
not a COVID case. I think a lot of times it gets lumped into the landscape of COVID because that was the environment that birthed the Freedom Convoy, which to the government birthed the Emergencies Act. So this isn't a COVID case. But I do think if we look at all of the pandemic challenges that have been there in the last couple of years, one thing you and I have talked about, I'll say lamented on stage and on this show, has been how deferential courts have been to the state over this period, including on freedom of expression issues. So it is really a divergence from what a lot of the jurisprudence has been on some of these cases of this era over the last few years, is it not?
It is. Yes, I think that this was a case, though, where I think one of the issues with the COVID era cases was evidence, and
Hmm.
that it was difficult to litigate with the scientific evidence as the basis about, how dangerous is the virus, and there was a lot of deference given to the government about that, and there was a kind of a lack of scientific evidence that was in the court cases themselves. Now, some of the cases, there were some in Manitoba that had some discussion of the evidence, but for the most part, it was not litigated on the science. So it was, in the end, the courts ended up having deference to the government. In this case, this is a more straight principles of law, and there actually, in this case, was a huge amount of evidence because of the Rouleau inquiry. We had
Hmm.
all of these affidavits. We had all this evidence from testimony, from policing experts, from cabinet ministers. So there was a lot here to help the justice reach this conclusion.
And you also had the government attempting to have this dismissed on mootness grounds, which the judge clearly did not do. And I think we can be very grateful for that fact. But that was one that I found quite notable, that we have such a massive, unprecedented legislation, incredibly controversial usage of it, and the government didn't even want there to be a judicial review on it.
Yeah, I think that that's such an offensive notion, that this piece of extraordinary legislation, that by its very nature is temporary. Anytime you invoke emergencies, are just temporary by nature. That's what makes it an emergency. And the idea that you could never scrutinize the use of this legislation, because by the time you get to court, the emergency is over. This is like a preposterous type of suggestion by the government. And now the judge, Justice Mosley, did find that the case was moot. I mean, the facts on the ground were done, but of course, courts have the inherent discretion to hear a case in spite of its mootness. So he did proceed to hear the case, even though the protests obviously had resolved and the emergency declaration had been revoked. It was only in place for a very short period of time, and this was a huge issue in the hearing, where Justice Mosley just did not seem to be buying it at the hearing. He said, in what context would a court ever hear a challenge? Because it's always going to be over. The emergency is always going to be over by the time it gets to court. And the Attorney General really tried to wiggle out of that one. But I mean, it is what it is. And the judge is right in this case. It's always going to be over by the time you get to court. And we're happy that this absurd mootness argument was rejected.
We are going to have you back tomorrow for a deeper dive into this once you've had a chance to pore over it here. And I know there are going to be a few things that you'll be looking out for specifically, but I just wanted to ask you, is this effectively a guarantee that the government is going to appeal this to the Federal Court of Appeal?
If I were a betting woman, I would bet they're going to seek leave to appeal. It's They haven't said so yet, but I would be absolutely shocked if they don't appeal. I mean, I'm interested to see what the government's statement on this is, because I mean, it's a brutal loss for the Trudeau government today.
Well, and you may not have seen this. They had a bunch of media appearances planned from ministers who have all now gone into hiding in Montreal.
Did
Like Bill
not
Blair
see
was
this.
about to speak, and now they've shoved him out the back door and canceled this. So
One
I
thing
think
I
they're
would say, though, Andrew, is that I mean, I'm certain that the government is going to try to appeal this, or they're going to seek leave to appeal. They haven't said it, but I would bet that they are. And this is a case that is tremendously expensive. So if your supporters care about this issue and they want to see us successfully fight an inevitable appeal, they can make a donation to our legal fees at the ccf.ca/donate.
Yeah, there was no. I noted in the decision there was no cost award here, so it's not
No.
even like the government is forced to give you a token for having
So
bought this.
we actually typically don't ask for costs.
Okay.
There's maybe a few exceptions, but I mean, that's taking your and my money, Andrew, because we're always suing the government.
You're
And it's
taking the
taxpayer
libertarian
money.
approach. Let those who
Yeah.
support this fight support you. Well, that website is theccf.ca. Again, Christine, congratulations. We will talk to you on the show tomorrow in a bit more depth on this, but well done.
Wonderful.
You're tuned in to The Andrew Lawton Show.
That was my first discussion with Christine Van Geyn, and as I promised at the end of it there, we would have her back on the next day when both she and I had the opportunity to delve into the decision in a bit more detail, which is what we did. So this was my interview with Christine on Wednesday's show. Now that you've had the chance to look through this, I'm curious what your takeaway is, because obviously you agree with the outcome, as do I, but the reasoning behind it, do you find it's sound, and is it based on what you would have hoped as a lawyer it was going to be based on?
Yeah, so these are very detailed reasons where Justice Mosley goes through not just some of the preliminary matters like standing and mootness, but really dives into the crux of invocation. So he spends a lot of time dealing with whether or not the threshold to invoke the Emergencies Act was met. And then he looks at, once finding that it was not met, then he goes through the measures enacted under the Emergencies Act. That was the freezing of bank accounts and the prohibition on gatherings. and found that those were unconstitutional. So we can talk about any of those. He also gave a shout out to counsel. He said that one of my favorite quotes was at the end of the decision, and he said that the advocacy was wonderful. And he said in kind of radical transparency, he said, when this case started, I was leaning the other way. But for the advocacy of groups like the Canadian Constitution Foundation and the Canadian Civil Liberties Association, this case could have very well turned out differently. So to receive that type of sort of shout out from the bench is it's a wonderful, wonderful feeling.
I wanted to ask about that actually, because I've not read as many of these things as you have. I've read probably more than is healthy for a normal person, but I've not really come across a judge being that transparent about their own evolution on a case like this. Whereas he was basically saying, look, at the beginning, I was leaning this way. Is that as rare as it seems on the
It
surface?
is. So judges will sometimes, if counsel is particularly good or particularly bad, either give a nice or a mean shout out to the lawyer and say that this counsel
Mhm.
was exceptional or this counsel was bad. You don't want to be the on the bad end, because then
Well,
forever
there was
your
one of
name will
those
be
in this case
official.
too. I
It
saw it
was,
was one of the
yeah,
groups, Canada Frontline Nurses, just got a
yeah.
rather scathing rebuke by the judge.
Yeah, I was there in the courtroom, so I saw what the lead up to this was, and I frankly, it was pretty well deserved. I wasn't surprised that there was some criticism from the bench of that one
Mhm.
particular lawyer, because his argument started with a discussion about the prime minister wearing blackface, which of course he did, but it's not
But
really
it's not
relevant
there's not really a
to the
legal
case.
argument, in that. It's more of a just by the way.
Yeah.
Yeah.
Anyway, yeah, it is rare to receive a kudos like that from the bench, so we were very thrilled to get that.
I wanted to ask you because one of the things you and I spoke about when your book came out, Pandemic Panic, not that long ago, was that freedom of assembly is a very underdeveloped area of law. And I was curious what your take was on if that's a bit more developed now or if that really weighed in this decision in a meaningful way.
So Justice Mosley wrote that there was no breach of the right to freedom of assembly, because he said the right to freedom of assembly comes with a caveat, which is freedom of peaceful assembly. So he was not concerned with the gathering limits breaching that right, because he said the gathering limits prohibited participating in a gathering that that could reasonably lead to a breach of the peace. So he said those gatherings are protected anyway. I mean, I do quibble with this, because I I don't want to say too much, because it may be a ground for appeal. It may be involved in the appeal, but I understand the position that he took, because it does have that caveat in the right, but I don't agree with the conclusion that that right was not violated. But the important thing to know about the right to freedom of assembly is that it is an underdeveloped right in our charter. There's not very much jurisprudence on the right to freedom of assembly. And we wrote in our book that the pandemic presented a number of opportunities to develop a legal test of what constitutes an assembly.
Mhm.
Now, in this case, there clearly was an assembly. Um, the question on whether or not something is an assembly more is geared to whether, private gatherings like a Thanksgiving dinner would constitute an assembly under the charter. I think that it would, given that the text of the charter doesn't delineate what the purpose of the gathering needs to be. But anyway, that's sort of not what this case was about. He found there was no breach of the right to freedom of assembly. The breaches were the right to freedom of expression, because a protest is an expressive event, and he found there was a breach to privacy rights, that the disclosure of information from bank accounts was an unreasonable search and seizure that was unjustified.
I wanted to ask about something that follows up on a discussion we started yesterday, which was the distinction between this and the Public Order Emergency Commission. And just to bring people up to speed here, the Public Order Emergency Commission was a creature of statute. It's mandated in the Emergencies Act itself that there must be this review. And at the end of that rather exhaustive set of hearings, the commissioner, Paul Rouleau, found that the government was justified, that it basically complied with the tests set out in the Emergencies Act. Now, the federal court has found the opposite is true, that it was not justified. And I'm curious now that you've dug into the decision where that divergence took place and where, if there was like a pivotal point, Justice Mosley disagreed with basically Commissioner Rouleau.
So he doesn't say that. I mean, it's obvious that he is disagreeing, but I think from what seems like one of the key areas of disagreement is on the threshold of threats to the security of Canada. And that is not what this case actually turned on. This case turned first on whether or not a national emergency existed, and Justice Mosley found that it did not. But the real question for lawyers who are interested in the Emergencies Act is this issue of what is a threat to the security of Canada. And in the legislation, the Emergencies Act, that is a term that the legislation says has the same definition as given to the term in the CSIS Act, another piece of legislation. And the CSIS Act requires there to be a threat or actual serious violence for a ideological or religious or political cause. And Justice Mosley disagreed with Justice Rouleau about the flexibility of that definition. And Justice Mosley found that term, because it's defined in the statute as having the same meaning as another statute, there can be only one reasonable interpretation. It cannot have the myriad of possible interpretations that the federal government has tried to give it, which includes things like economic harm, because there were border blockades. Justice Mosley found that economic harm is not a threat to the security of Canada under the CSIS Act, and it is not a threat to the security of Canada under the Emergencies Act. And he said, perhaps it should be. I don't know. Perhaps the legislature could amend it if they want that to be the interpretation. They should amend the legislation, but it is not the role of the court to do that, to amend the legislation. But, Justice Rouleau did accept the government's interpretation that threat to the security of Canada had a sort of different meaning under the Emergencies Act than it does under the CSIS Act. And the government has continued in the announcement of their appeal to make that case that it has this broader definition that actually includes economic harm.
One of the things that I think is probably and will remain in the history books as the most heavy-handed aspect of this is the freezing of bank accounts. I mean, after you and I spoke yesterday, I had Tom Marazzo on and also Eddie Cornell, two people whose bank accounts were frozen. Cornell was actually one of the applicants in this case. And this remains incredibly overbroad. There were, the government sort of held as its defense to this, well, we only froze this small handful of accounts, but the way the emergency orders were written, they could have frozen many, many more. I mean, anyone who had donated a dime to the truckers would have been fair game as I read this, and as most people would. So I'm curious how the judge really took that, because I did see one section in particular that stood out in which Justice Mosley talked about the indiscriminate nature of it, that the government really didn't do anything to prevent spouses from being affected who had nothing to do with the convoy.
So, okay, a few things. So the bank account freezing, Justice Mosley found was a violation of the Charter's Section 8 guarantee to be free from an unreasonable search and seizure. Now, in court, the government had argued that this was not even a search, which is frankly preposterous. And Justice Mosley, in the hearing, basically told them to stop wasting their time and get to Section 1, whether or not it was a justified search, because he's like, I don't know, I forget his exact words, but in the hearing itself, he was not buying this argument that this was not a search. So we know that the examination of financial records is a search. Like, there is a lot of case law that says that financial records are part of what we call the biographical core of personal information. It can reveal all kinds of personal details about a person. So, like what your socioeconomic status is, what your lifestyle choices are. I mean, frankly, I don't want my husband looking at my credit card bills, let alone Justin Trudeau. So clearly, this is a search. The orders required financial institutions to give this information to the government, to police, to CSIS, and to the RCMP. So the other thing Justice Mosley said, this is a search. The other thing he found was he had to look at whether or not the search was minimally impairing, whether it was a justified limit under Section 1 of the Charter. One of those criteria is that it be a minimal impairment of the right. And he found that the suspension of bank accounts and credit cards affected joint account holders and joint credit cards. So people who had absolutely nothing to do with the protest, if they were at home in Toronto or Alberta or British Columbia or some other part of the country, having nothing to do with the protest, they might not be able to use their credit card or get into their bank account to buy groceries or to buy medication. And that happened to one of the applicants in this case. That happened to him. These family members had absolutely nothing to do with the protests, yet their accounts were frozen. That's not minimally impairing. And Justice Mosley found that the government took absolutely, this to use his words, he said he found there appears to have been no effort to find a solution to that problem. Another thing that Justice Mosley found on the credit card and bank freezing was that there was no clear standard that applied to determine whether someone would be a designated person and have their account frozen. So the police say we only froze the accounts of people who were heavily involved in the protest, but the regulations don't actually say that. So as you pointed out, someone who had simply donated to or supported the convoy might be subject to being targeted. There was no clear standard. And Justice Mosley described the process for freezing the accounts. To quote him, he said, the police just making it up as they went along. And then he also found once your account was frozen, there was no process to question the determination of why your account was frozen or how to get it unfrozen. So a lot going on there that clearly a breach of Section 8 of your right to be free from an unreasonable search. And Justice Mosley found that breach was not a justified limit on your charter rights.
Were there any of the emergency measures that he defended that he said, actually that wasn't unconstitutional?
So he said that there was no engagement of the Bill of Rights. There was some argument on Bill of Rights. He was not interested in the arguments on international law. He found there was no breach of Section 7, which is the right to life, liberty, and security of person, because he said, while some people were detained when they were arrested, I believe he said they were arrested under the ordinary criminal code, and their detention was brief. So,
Because one aspect I was interested in was, partially for selfish reasons, was the way that journalists were excluded from even reporting on this. I mean, there were some this would be something that would probably have to come up in a separate case, but there were situations.
Excluded or pepper sprayed, Andrew?
Well, both. I mean, in my case, pepper spray, but even excluded. And you had on the ground some very inconsistent decisions, like police saying that you don't have a right to walk down a sidewalk because they've decided that this is now an area that they're clearing out. And, in my case, I had a couple of points where I was threatened with arrest, even though this is the day after the protest had been dismantled. But I'm wondering, when you look at this from your perspective, and I don't want you to give the government ideas here, but the government had committed to appealing this basically before the ink was dry and before they had a chance probably to.
I don't think they expected to lose.
Well, fair enough. But I'm curious where you think they'll try to dig in on this and where you think they'll try to base their appeal.
So they can only appeal what are referred to as mistakes of law. I mean, that you can also appeal what are called mistakes of fact, but that's a lot harder. It needs to be what's called a palpable and overriding error. And so there were a number of findings of fact in this decision that will be a difficult hurdle to overcome. So on this question of threat to the security of Canada, one of the things Justice Mosley found was that the only evidence of any threat of serious violence, which is part of the threshold, was in Coutts, in Coutts, Alberta, where a number of people were arrested and had firearms. And Justice Mosley wrote that while obviously concerning, and of course it is concerning, those individuals were arrested before, I believe, before they were arrested under the ordinary criminal code. So part of the threshold is the requirement that no other law can be used to deal with the situation. And clearly these individuals were arrested under the existing criminal code. So the fact that Justice Mosley kind of found that the evidence showed there was only one threat of serious violence and it was addressed using the criminal law I think that is a finding of fact. The government can't now bring new evidence to show, there were other hardened terror cells around Canada that were a huge threat. They're stuck with that finding, and that can't really be overcome, at least not very easily. I think on errors, what they have to focus on is what we call as lawyers errors in the law. And I mean, I don't think there are errors in law in this decision. I agree with this decision completely. But based on what Chrystia Freeland said in her press conference yesterday, it seems like the government continues to emphasize this notion of threat to the security of Canada and the standard including economic harm. So they seem set on that argument. But I will say, before they can even get to that, Justice Mosley had already found that the use of the law was unjustified because he found that there was not a national emergency. And that alone was enough to find that the invocation was unreasonable.
Yeah, and the government's insistence that economic harm even qualifies as all of these things under the Emergencies Act, I think is very, very questionable in a lot of ways. I wanted to, just before we go here, draw attention to, if you're following along at home, everyone, para 308 and 309 of the, I see Christine's following along. She's, I see her looking for the monitors there. Basically, what he's saying here is that there was no real distinction between people that had a truck that were blocking a border effectively or blocking Wellington Street and people that just wanted to stand on Parliament Hill with a Canadian flag and stand up for freedom, as is always legal, is a legitimate form of protest. And that was something that it came up slightly in the Public Order Emergency Commission, where Commissioner Rouleau asked at a couple of points if there was ever an alternative presented. You can continue your protest, but here's how. And I appreciated that Justice Mosley did dig in on that, where he said, hang on, someone who wanted to stand there as an individual and not block a street was treated the same way as someone that parked a semi in front of Parliament Hill.
Yeah, so this is in the part of the decision that's dealing with charter infringement. So the way the Emergencies Act was invoked, the government created regulations, and one of them was a restriction on participating in a gathering that could reasonably lead to a breach of the peace or materially supporting the gathering or traveling to that gathering. And insofar as the prohibition would stop you from sitting in a semi truck on Wellington blasting your horn, perhaps that might have been okay. But this prohibition was not minimally impairing, which is what is required for it to be constitutional. It captured too many people. So yes, it captured the person who had spent 3 weeks on Wellington Street, which is not, you can't blockade infrastructure indefinitely. That we are a rule of law country. You cannot do that. That is not protected expression. But it captured that person, but it also captured a person who had a poster that they wanted to walk with to Capitol Hill or Parliament Hill and stand on the grass, which is completely protected expression. So it captured too many people. It was not minimally impairing, which is one of the requirements of a law if it's going to infringe on a right, which this did.
Well, I'll give you again the congratulations, well earned, that I gave you yesterday on the show. And now the judge himself has also lauded you for your work, which I hadn't seen yesterday. So well done all around on this, Christine. I look forward to having you back on as this case proceeds. I mean, the best case scenario at this point would be for the Court of Appeal or the Federal Court of Appeal to say there's no appeal here, right?
I'm not sure if they get leave to appeal as of right or not, but I think certainly if leave is the permission of the court to appeal, if I think that they would get it. I think an interesting question is if whatever the outcome is at the Court of Appeal, I mean, the timeline that we're looking at is probably 6 months from now, an appeal could be heard, and then 6 months from now, we might get a decision. But
So
if
a
we
year until there's a federal court of appeal decision, you're thinking?
I think at a minimum, and then when we talk about if there's any possible delays, how close are we pushing it to an election? Because I do think if there's a change of government, the desire to appeal this decision will perhaps be lacking.
Yeah, fair enough. But assuming just that it goes through the normal channels here, you've got a hearing under the federal court of appeal decision, and then potentially beyond that, Supreme Court of Canada. How long would that add to the timeline?
Another 6 months for the appeal, and then 6 months for the decision.
So
Although
and you're right. So we're well into, I mean, a year into the next government's term, possibly, whether there's a change or not. So ideally here, there would be a bit of contrition from the federal government, but right now we're not seeing that.
I think they'll probably rush it because I think they can read polls as well.
Yeah, fair enough. All right, well, we'll get the political analysis next time. Christine Van Geyn, litigation director for the Canadian Constitution Foundation. Well done on this, and thanks so much for coming on again.
Thank you.
All Christine all the time. That was what I joked about after the end of that second interview. Hope you enjoyed that. We'll be back Monday with another brand spanking new edition of Canada's most irreverent talk show here on True North. Thank you, God bless, and good day to you all.
Thanks for listening to The Andrew Lawton Show. Support the program by donating to True North at www.tnc.news.